Andrew, thanks for coming in to talk to us about this interesting topic. So I'll hand over to Andrew to give us the benefit of his experience of so many years in practice in the city.
Have you all got the notes? Can I just check that? Right. Now, what I'd like to do here is start off just running through a few things that I've come across over the years of what I would regard as questionable practice. And then think about the civil law approach to those things to the extent that they may or may not give rise to some form of remedy for the consequences of the skullduggery that went on. And then perhaps at the end, if we've got time, I'd like to just come back quickly and look at some of the recent legislative reforms and whether or not that's going to make much difference to people's attitudes. So let's then start just with some of these questionable transactions. And some of these things occur on their own, and some of them are sort of taken in combination with other factors that I've listed here. So sometimes you'll see one or two of these things cropping up in the same deal. So you're not content with skinning the rabbit once, they want to keep skinning it right down to the bone. Right, promoting schemes which don't stack up. This is essentially, usually, floating companies on the market, IPOs and the like. And when you actually sort of sit down sometimes with the benefit of hindsight and say, did that thing really make sense? It turns out it didn't. And there are some pretty good examples of that going back to the early part of this century with the so-called dot-com boom, where companies were floated on various exchanges. And essentially what was happening was that a lot of people were taking fees and the founders were getting handsomely rewarded for founding the enterprise. The take-up for these things was very much leaning on the feverish nature of the market. And then when the dot-com boom came to an end, suddenly there's nothing there. The enterprise was not nearly as profitable as one might think. And we then see that again when the financial crash comes in 2007, 2008. When you look at businesses which had essentially been good, solid businesses where there's a buyout, and the buyout is funded obviously by debt, and then that goes on for a couple of years, and then there's another buyout funded by more debt, and you keep ramping up the price and what appears to be the value of this enterprise, and then it's gone. And I think we're seeing that again. Last week, it was reported that there's a whole lot of IPOs all stacked up and ready to go, and they're doing this because there's a huge appetite out there for subscribing to these things, and that's, I think, going to end again in tears. So the point I'm making there is that these things are structured and put together by investment bankers, and I think that they should have a duty to be much more honest in appraising these situations, and not just thinking, well, our job is to sell this for as much money as can be got in, but actually to say, is this a a proper commercially viable transaction in the longer term. And it's very easy to present your projections and so on, taking a very optimistic view of everything. It's a completely different thing to sort of say, however, if we change some of those assumptions, then maybe it's not so wonderful. I think much more of that needs to go on. So that's the first thing that comes to mind. The second thing is what's called financial assistance. Now, if you go back to the 1948 Companies Act, and there's a section in the 1948 Companies Act called Section 54, and those of you who come from Commonwealth countries may still have that section in your Companies Act unless you've upgraded from the 1948 Act. And essentially what that said was that any transaction which occurred in connection with a purchase of shares in the company was unlawful. That's as the courts had it interpreted. Essentially what the section was getting at was that the company shouldn't be funding a purchase of its own shares, or doing something else to assist in that purchase, like selling assets at an undervalue, or indeed selling assets immediately after it at an overvalue to square up the price, or guaranteeing the loan borrowed to buy the shares, and even worse, giving security for such a guarantee. And you can see the obvious mischief in that, because at the heart of company law is the concept of capital maintenance, that the capital of a company should be available to meet its liabilities incurred in its trading and business activities. That's the idea, that people who provide credit and so on to a company, if everything goes wrong, at least can look to the capital of the company, the shareholders' funds, as at least some source for payment to them. And anything which depletes the capital of the company is not right. And a deliberate attempt in a scheme under which the company is assisting in the purchase of its own shares, it has the roundabout effect of depleting the capital. So Section 54 appears, in fact it comes from the 1929 Companies Act before it, but it was a rather blunt instrument. So in 1980 it was modified so that it wasn't anything done, it was something done for the purpose of assisting in the purchase of the shares or assisting in a refinancing of such a purchase. So the obvious things like lending money again to the purchasers is still out, and giving a guarantee is still out, and various sort of mucking around with the assets to change the value of the company is still out. But entering into a legitimate contract simply at the time of the purchase was accepted from it. So that's understandable, but what came with it is less understandable, which was that a procedure was introduced for private companies, that is, companies that don't have PLC after their name, which allowed private companies to give this sort of assistance on the strength of an accounting exercise which essentially said that it would be unlikely that the value of the company would be depleted as a consequence. I'm paraphrasing, but that will do. And in consequence of that, since 1980, a vast number of transactions have taken place where essentially the money for the purchase has, one way or the other, come out of the company itself. Often, for instance, by selling off the assets of the company, which are sold at market price, therefore on a profit over the value in the company's accounts, thereby enabling a dividend to be paid, and the dividend is then used by the new shareholders to pay off the lending. That's one sort of way of doing it. And you can look at various Premier League football clubs where this happened and which have got themselves into a lot of financial difficulties in consequence. So that essentially what I'm saying to you is that this sort of relaxation of the overall principle, I think, was a bad thing. But of course, it's a good way of generating a transaction. If the buyers can, one way or the other, think to themselves, well, we're going to fund this out of the company's assets, then they'll go ahead with it. Now, it's even worse because the 2006 Companies Act has essentially made it a free-for-all in this area for private companies. You don't even need to go through those accounting exercises now. So long as the shares that are being acquired are not in a public company, or that there's not a public company somewhere between the people giving the assistance and the purchasers, so between a subsidiary giving assistance and the purchasers, you don't even need to go through the accounting exercise any longer. And so that basic idea of preserving the capital of a company for the rainy day, so that the creditors of the company have something to look to, has been smashed. And I said to you, it can't involve a PLC. Well, that's easy. You want to do a takeover of a PLC. You borrow the money to do the takeover. The day after the takeover, you turn the PLC into a private company, and then you refinance it using the balance sheet of the now privatized company to support the new financing. Asset stripping.
So, before you move on, I'm hoping we could ask questions while you speak.
Yes, please do.
You mentioned the issue of maintenance of capital.
Yeah.
And I just wanted to get your view on the debate going on about whether it hasn't become an across stake issue, looking at the arguments of Amo, Ferro, and Eligas, and then people were saying that the second corporate law directive should relax this issue of capital maintenance and minimum share capital, and probably move on to more of a balance sheet or a solvency test. What's your view? Are you pro or like these things?
Well, one problem with doing anything on a balance sheet test is that there's no end of the mind of man in creative accounting, and you can there are all sorts of ways that you can revalue assets in a balance sheet. Whereas at least with capital that's paid up, you know how much it is because that's what was paid up. So if £100 was paid up for share capital, then there's £100 of share capital there. And you can't engage in any creative accounting exercise to change that value. Yeah.
So I want to ask, if we go back to the private companies where the minimum capital could be £1.
Yep.
So how does the argument works in this field, where the capital doesn't actually help the creditors to get any money?
Well, the theory at least is that when people are dealing with a company, they'll have a look and see how much capital it's got. I know in practice that may not happen, but at least you can find out. You can do a company search and you can see how much paid up share capital it's got. So in making your decision whether to deal with the company and give it credit, you can see how much share capital it's got.
that how much would be an acceptable threshold? So you look at the public company, the provisions they declared at £50,000, €25,000, depending on whether it's a company or director or the UK. And then you say, okay, let's take the threshold to £1 million. Then you look at the kind of transaction public companies going into and how they amount to millions and billions of pounds. What would be the threshold for you to say, oh, you have a capital maintenance that would be sufficient in case something goes bust in this instance?
Nothing. I mean, my point is really that when you look at, say, some of the football clubs, and you look at the paid-up capital they had, it was in the hundreds of millions. And I've got to be a bit careful because I'm being televised and recorded, so I can't actually say who it is. But one of the top Premier League football clubs had a nice, serious amount of paid-up share capital, and has now been in the red for a long time. And that is because of the financial assistance scheme that was done at the time when it was bought out by some foreign investors. I don't think I should say any more than that. Asset stripping. Let me give you an example. Woolworths. Woolworths was a large chain of shops in the UK which specialised in the sort of the poorer end of the consumer market. And there were Woolworths shops on virtually every high street. And they sold a whole range of consumables. They were subjected to a number of transactions where they were bought out by venture capitalists and the like, and each time the price of the company on the next sale was increased over the one before. And the last of these was essentially done on the basis that they revalued all of the shops, the land, and did the buyout on that, and then sold all the land to finance companies who then leased the land back to the shops. Of course, the lease rentals having to reflect the price that the finance companies had paid for the shops, which was unsustainable. Woolworths was not generating enough revenue to pay that level of rent. It was a perfectly viable business if you hadn't gone through all of these arrangements, ramping up the value, finally stripping out probably the most valuable thing in terms of their assets, and then making them pay a huge amount of money for the use of those assets, so the whole thing collapsed. And a business that employed 5, 6, 10,000 people no longer existed. And what's worse, of course, nobody wants the shops now. So all those shops are lying vacant. So that land is not being used. All those people have lost their jobs. That business which provided cheap consumables to the poor has gone. Now, where is the justice in that? Derivatives transactions. Have you dealt with derivatives transactions in your course? Okay. How can I explain easily a derivatives transaction? Well, let me just give you an example of two fairly straightforward derivatives transactions. First is a thing called an interest rate swap, which is, let's assume that you have a borrower borrowing interest at a floating rate of interest. but the income that it's generating is really on a fixed rate profile. So the risk it's taking is that what's coming in sort of fixed amounts may not be sufficient if floating rates of interest go up. So you need to protect yourself. So what you could do is enter into a derivatives transaction by which somebody else, in my example, who's got the exact opposite sort of cash flow profile, will essentially pay you floating rate of interest on a assumed or real capital sum every 6 months, which enables you to meet your interest obligations on your own loan, and you at the same time pay that other person interest on that capital sum at a fixed rate. So everybody's happy. He's getting the fixed rate of interest he needs, you're getting the floating rate of interest you need. And designed as that, it's a perfectly acceptable transaction. It's a proper form of hedging. Now, it's thought that the first of these transactions had to do with a bond issue back in about 1960, where the bank raising the funds was paying floating rate interest on the bond issue, but was essentially getting in interest from its borrowers at fixed rates. So you can see how an interest rate swap can work for its advantage. And a currency swap is very similar, which is I want to borrow, say, in US dollars, but my revenue stream is in, say, Swiss francs. So my concern there is a movement in exchange rates as between US dollars and Swiss francs. So I need to make sure that the Swiss francs that I'm getting into will be sufficient for me to meet my loan obligations denominated in US dollars, both in terms of interest payments and in terms of capital. So what I do is I find another bank which has the exact opposite problem, and we enter into a currency swap so that I'm provided with the Swiss francs that I need, and he's provided with the US dollars he needs. And it's thought that the first of those deals was a fundraising exercise by the World Bank, again in the early 60s. Now, looked at in that perspective, that's all perfectly justifiable. What is the risk you're taking there? Oh, looks great, but where's the risk? Well, it's failure of your counterparty, isn't it? If I'm relying on somebody to provide me with certain amounts of currency and he fails, then he's not going to be providing me with that currency, is he? But anyhow, leave that to one side. So that's fine. And so originally we start off with these types of transactions linked to the real world. There is a real underlying need per transaction for each of these hedging arrangements. And as long as you satisfy yourself on the risk profile, that's great. So they started off tending to be done between banks, big financial institutions. The next stage is to say, well, rather than hedging against specific transactions, I'm going to hedge protection for a whole block of business that I do. So, I lend £500 million of mortgages, and my funding for that is in US dollars, so I need to swap on a whole book basis rather than a transaction by transaction basis. Again, no great problem with that. But then we get to the next stage, which is I think I can enter into a profitable business by entering into derivatives transactions because I'm smarter than the next guy. And I can spot the trends. And so rather than this being, at least from my perspective, genuine hedging, it's gambling in reality. And it can be, if you get it all right, intensely profitable. But of course, one man's profit is another man's loss. And we keep ramping these things up, and the volume sizes of the derivatives markets get to $50 trillion on assumed underlying principal amounts, when in reality the real underlying principal amounts is significantly less than that, something like only 10% of the derivatives market is actually matching real underlying transactions. So banks in particular are then engaging in huge bets on movements in markets of one sort or another. And the complexity of the style of derivatives transactions increases as well. So you move away from sort of the two simple examples I've given you to things that are much more esoteric. And that leads to Lehman Brothers. And it leads to the collapse of AIG. Because when the chickens came home to roost, they didn't have the money to pay up on their obligations on the derivatives transactions, which were mostly fictitious anyhow. So I guess the question I'm asking you is, to what extent, when you're allowing market trading in commodities, in securities, in financial products, to what extent should there be some requirement that there is a real linked transaction to it, and to what extent do you just allow people to trade almost in the ether? Because if you allow that, then that leads on to a very overheated and unrealistic market. And a good example of that is subprime lending, where derivatives transactions were part of the overall package. Now, what happened in subprime lending, and this is what triggered the collapse starting in 2007, is you get, particularly in the US, people being enticed into borrowing mortgages on property, houses, which they really could not afford. So you're right from the outset, if you actually take these things apart, you find mortgage transactions that at some point are bound to go wrong. But if you package all these things up into a securitization and then sell the whole package on, it was thought that you could add in various things like derivatives transactions and so on and so forth, so that it suddenly looked very good for people in the marketplace to be buying the capital markets instruments that were issued to fund the purchases of these mortgage portfolios. And the merry-go-round just keeps merry-go-rounding around. So not only do you then sort of have a package of a portfolio, but you into a securitization and the issuance of securities in that, but then you securitize a whole portfolio of the instruments that have been used to fund the securitization. And some of them sort of went 3 or 4 steps along that chain. And by the time you sort of get to the last of the deals, it's, a piece of land in Arizona seems a heck of a long way away. But then the merry-go-round stops. And the final guys who are in the market for short-term notes stop buying short-term notes. and eventually the whole thing cascades right back, and lo and behold, the mortgages are all in default. Now, why didn't the people who devised these products think about that? Or perhaps they did, but they were so busy trading it and getting rid of it that essentially they didn't care. They just put the deal together. Short selling. Short selling is essentially where I spot that for some reason that I think the market's about to go down, usually in some form of security or other. So I enter into a transaction to sell these securities at the present market price when I haven't got them myself, confident in the expectation that at the date I've got to deliver them, the market price will have already gone down. I can buy at the lower market price and make a profit. Now that, in my view, inherently will destabilize markets. And it's usually done because the short seller is in a favoured position and has some good reason to know why the market price is going to go down. Vulture funds picking up debt instruments on the cheap. So you remember this morning I mentioned these vulture funds. And essentially what happens there is the issuer of debt has gone bust, and its debt is now trading at a significant discount to the par value. And these funds buy up the debt, sometimes at sort of 10% of the par value or something like that, which is probably what it's worth at the time. But they can specialize in making a nuisance of themselves so that they have to be bought out at a profit to them, or the whole enterprise will collapse. And that's happened quite a number of times. As I think I mentioned to you, Argentina is a good example of that. A deal was done under the auspices of the IMF to try and put a sort of rescue package into Argentina a few years back. And nearly all of the creditors signed up to this and were prepared to agree to the new deal. But some of the debt was held by vulture funds, and they basically held out and refused to go along with the deal. And the only way of quietening them was for them to be bought out quietly. So they make a big profit, essentially relying on everybody else's desire to see the thing through. This happens quite a lot in capital markets instruments where the issuer is in financial trouble. Creative accounting techniques. Anyone from Greece here? Well, if you want to sort of think about creative accounting techniques, then think about Greece and the creative accounting that went into its entry into the euro. And we all know where that's got us to. But I mean, that's just a sort of fairly blatant example of a bigger problem, which is that you can exploit accounting rules to make the situation look rosier than it really is. It's not as easy as it used to be. When I started in practice, it was not uncommon to find that towards the year end, if things were looking a bit dicey, the board of directors would sort of think to themselves, well, our head office building is currently in the books at so much, and well, perhaps we'll just double its value. And you can either pass that through the P&L account, or you can put it straight into the reserves. Whichever way you do it, it makes the position look a lot rosier than it really is. Now something as blatant as that you can't do now, but it gives you an idea of tailoring your accounts to suit the particular need that you have at that time. And you must always be very careful when you're reading a set of accounts. Look carefully at the notes, look carefully at the assumptions that have been made in compiling those accounts, and think about the alternative accounting treatments and which one they've opted for. And if possible, think to yourself, what if a different accounting treatment, or what if different assumptions were applied? When you're looking at financial covenants in a loan agreement, you'll normally see there's a clause in there saying you won't change the way you prepare your accounts without our permission. Or if you're dealing with a listed public company, it's not so easy to say that. So you say, if you do that, you must prepare an alternative set of accounts on the old basis and submit them to us, and our financial covenants operate on the old basis rather than the new one. The bonus culture. I don't understand why people who are paid well in excess of £1 million a year as their basic salary have to be paid a bonus to get them to do a good job. And that's the philosophy behind the bonus culture. That if you want these high-flying people to do a good job for the bank, you've got to give them a bonus by way of reward for their efforts on top of a pretty big basic salary. The chief executive of HSBC has just been awarded a bonus on top of his basic salary of $1.2 million a year of £32,000 a week. I would have thought he was rich enough as it is, but that's not the end of it. The former chief executive of Barclays, when you added in the bonuses on top of his basic salary entitlement, was getting something like $24 million a year. Good money if you can get it. I wish I'd thought of it. Now, the bonus culture just sort of seems to be almost sort of an inherent part of finance at the moment. HSBC last year showed profits of $22.5 billion, and its bonus pool for its senior staff was $3.9 billion. That's on top of their basic salaries. Lloyds Banking Group, which last year managed to lose £8 billion, felt it had to put aside a bonus pool for the excellent performance of its staff, generating that magnificent loss of £600 million. The scheme had become so stupid that a few years back, the retail banks in the UK were paying their branch staff, the guys behind the counter in the branch, a bonus for selling financial products. So it's the worst of it's at the top, but it had actually, the culture had got all the way down to the bottom. Lloyds Bank even took it a stage further with some of its staff and reduced their salaries for lack of sales performance. Now, the world's gone completely mad if that's regarded as being a moral society. Something's wrong with that. And don't forget that these guys that are being paid these huge salaries and bonuses are not actually putting any of their own money into the business. They're not risking anything other than their own reputation. It's one thing to say that the shareholders should get a dividend payable depending on the profitability of the enterprise, because the shareholders have put their own money in. They are taking a risk, and they deserve reward for the profit that is generated from the business in which they've invested their risk. But these executives in banks, they don't own the bank, and yet they are getting massive profit out of their activities. Now, you can test the morality of that by thinking about some of the things that have gone wrong. And I mentioned PPI mis-selling, payment protection insurance mis-selling. One of the reasons that Lloyds Bank managed to lose £8 billion last year was that it now has put aside something like £12 billion into reserves to meet claims for mis-selling of payment protection insurance. Does everyone know what I mean by payment protection insurance? Essentially, and it was mainly consumer lending, that not only would you be lending them the money, but you would be selling them an insurance policy to cover the consequences of illness or losing their jobs or something like that. So that the idea was that if those things happened, the insurance would step in and meet their obligations for, say, 6 months. The problem is that most of the people to whom they sold these products either didn't need them or would not have been eligible to claim on the insurance if things went wrong. Like, they were selling these things to people who are self-employed, and self-employed people were not covered. They were selling these products to people who had a serious illness, and loss of your job for a serious illness was not covered. So bad was this that the combined amount of the big banks in the UK set aside as provisions to meet PPI claims is now £20 billion. A significant part of Lloyds Bank's profits for the last few years was generated by the sale of PPI. And as I said, to make sure that the sales happened, they were motivating the branch staff to try and sell you a PPI product when you went into the bank, or when you took out a consumer loan. You often weren't even told that part of the deal was buying PPI. I queued up once at my bank, NatWest, in London, to pay in a cheque, because I like to get a stamp on my paying in book, so that they lose the cheque, I can say, but I can prove that I paid it in. Then the fellow in front of me was also paying in a cheque, and it was, I think it must have been £20,000 or something. And the lady behind the counter looked at the cheque and said, "Could we possibly give you some advice as to how you might invest this money?" This is a 19-year-old bank clerk, and she gets basically 50 quid for every reference she makes of a customer to one of their so-called financial advisors. And this guy said, "Have a look at who the cheque's drawn on." And it was clearly drawn on some financial institution. He said, "Yes, but can't we give you some advice about how you might invest it?" And so he said, "That represents my payout for being missold a financial product. But can we advise you on how you might..." I mean, she just she couldn't understand that this guy was sick of being given financial advice and had got 20,000 quid or whatever it was for settling his claim against whoever had given him the dodgy advice. Now, the EU intends to bring in restrictions on the level of bonus that can be paid to senior executives of banks, and basically you can pay up to 100% of basic salary as a bonus, so you're already 100% ahead of where you would have been, or 200% by way of bonus over basic salary with shareholder consent. So if you're on $1 million basic salary, without shareholder consent, that can be increased to $2 million. And with shareholder consent, it can be increased to $3 million. Now, you would have thought that would be sufficient for most people. The banks are squealing like stuffed pigs about this. And they're threatening legal action and you name it. But not only that, they've now worked out how to get around it. And who's at the forefront of that? HSBC and Barclays. So they are now awarding their senior staff non-refundable expense allocations by way of shares in the enterprise. Okay, there's a restriction, I think, of 3 years on cashing in on the shares, but that's not very long. I'll come back to the sort of point I made before. I don't understand how anybody who has any sort of inkling of professionalism in their job, who is being paid pretty well anyhow, and thinks that they need a bonus to do a good job. Where's the morality in that? Now, okay, the answer that the banks provide is, well, if we don't pay these bonuses, they'll clear off to somewhere else. Well, my attitude is, if they're that sort of person, let them clear off. There'll be somebody else who can do the job just as well, who'll come along. And then we get on to LIBOR fixing and Forex fixing. Do you all know what I mean by LIBOR fixing? Does everyone know what I mean by LIBOR? Anyone not? Don't hesitate to say if you don't. Everyone knows what LIBOR is? You don't? Okay. LIBOR stands for the London Interbank Offered Rate. It is the basic world benchmark for interest rates. And it is set each day for each major currency and for definite periods of time. So, and it's set at 11 o'clock in the morning. So at 11 o'clock tomorrow morning, the banks active in the London interbank market will be agreeing the rate for lending each of the major currencies to each other for definite periods of time. So overnight, a week, a month, 3 months, 6 months. Those are the basic periods. And the way it's done is essentially that they provide their quotes for essentially what they're prepared to pay to be lent money for those periods to a central sort of repository, which then adds up the rates and comes to an average. And that is published as the LIBOR rate. And LIBOR is used not just for straightforward loans and bond issues, but it's used in hedging instruments, all sorts of derivative instruments. Basically, any financial contract, really, around the world will be based on LIBOR, except, by the way, for most transactions in euros, which are set on a thing called Euribor, which functions in much the same way. And what these guys were getting up to in the financial crash was rigging the rate. So instead of supplying the real rate that was applicable to them, they would either supply a lower rate to make them look sounder than they really were, or a higher rate if they wanted, for some reason, to bump up the LIBOR rate. And at the moment, there's a lot of litigation going on, and there's been some huge fines doled out by the American regulatory authorities and the British ones as well. Quite a lot of the reason for doing that was people's bonuses were at stake. And there's some very interesting recorded tape conversations where someone rings up his colleague in the bank who's responsible for supplying the LIBOR, the bank's LIBOR quote, saying, could you possibly sort of shave it by a few percentage points, or could you possibly raise it by a few percentage points, because I've got a deal and we're going to lose packets of money unless you can do that for us. And lo and behold, the rate that goes in was shaved or added to accordingly. One of these chains of communications finishes up with, "Thanks, mate, I owe you a crate of champagne." And now it's come to light that they've also been fixing the foreign exchange markets, which again operate in London. And most of the exchange rates, both spot, which is immediate, and forward, which is for sales to take place in the future, are settled in London. And lo and behold, they were, and technically it's done again at 11 o'clock in the morning, and lo and behold, there were private conversations going on beforehand about, well, what rate do you think you'll be setting, and would be very helpful to us if you could sort of say this rate, and so on. And that little bombshell is just breaking now, and the regulatory authorities are looking at fines for that sort of thing. And we're talking about fines on the LIBOR scandal for, say, $1 billion, that sort of thing, so it's big. Insider dealing, market abuse. This is basically using some information that you have to make a profit in the market when you shouldn't be doing it. So you know something, say, about a company. You're an advisor to the company, or you're a director of the company, and you know something about that company which, when it becomes public, will affect its market price. And on the strength of your private knowledge, you deal before it becomes public, and you make, of course, a nice profit, or you avoid a nasty loss. Now, insider dealing, market abuse is banned, but believe it or not, it still goes on. So those are examples of dodgy transactions, dodgy things which in good moral conscience I don't think should happen. I don't know whether we'll ever fix it. The inventiveness of the financial markets knows no bounds, and you clamp down on one thing, and lo and behold, they'll think of something else. But those are just some thoughts of things for you to think about, and ask yourselves, as you go out into the world and pursue your careers, are you going to be part of that or not? Now, I thought it would be useful just to sort of compare present and past. Sometimes there's this sort of fond idea that in past times everything was moral and all the rest of it, and it's only more recent times when things have gone wrong. Well, that's not true. It may be that the scale of these things was not as bad in the past, and there are reasons for that. One is that ownership structures changed in the sort of 1980s. So whereas up to about the middle of the 1980s, investment banks, as they're now called, were owned by a small number of people. So the real profits were being sort of passed up to the owners, and there wasn't the opportunity for staff to demand huge bonuses because the money wasn't there. Whereas with the expansion of the financial markets, with financial institutions getting much wider sort of share ownership, much more capital going in, much more money to be made, and much more incentive as part of that to start paying bonuses and the like. Barclays is paying $3.5 billion of bonuses for last year's profit of 22 point something billion. So that's what, a seventh before the shareholders get anything. In a much smaller institution where the shareholding is much more tightly held, that ratio looks more extreme. And transactions are much more complex than they did. No one thought of subprime securitizations in the 1960s. They hadn't thought of securitizations. They just sort of thought about bond issues. So there wasn't the complexity and the number of different bits of a transaction on which profitable activities could be generated. But, and I do think we need to remember this, that the regulatory environment has changed too. In the 1960s, there wasn't any regulation. There was no Financial Services and Markets Act. There was no regulation, no legislation regulating banks. There was the only piece of regulatory legislation in the UK in the 1960s was something called the Prevention of Fraud Investments Act. And that was it. So, since then, one scandal after the other, more and more and more regulation has been imposed. So in 1979, after the banking crises of the 1970s, we get our first Banking Act. And then we get another one 10 years later or so. And then we get the Financial Services and Markets Act in 2000. In 1986, by the way, we've got something called the Financial Services Act, which is the first time that sort of a licensing regime is brought in for most types of financial services outfits. And now we've had yet more legislation amending the Financial Services and Markets Act and so on. So yes, there's a lot more regulation, but it didn't stop 2007, 2008. And I'm not sure that the even stricter regulation now is going to stop the next crisis. And you can speculate on why that might be. People were saying, for instance, about 2007, well, there just weren't enough people working at the regulators, and we didn't pay them enough. They didn't have the expertise, and they couldn't possibly keep an eye on everything. So we're going to pay them a bit more, but not nearly what their charges are getting paid. The guy who's overseeing the regulation of HSBC or Barclays is getting a fraction of the salary of the chief executive of those banks. And yes, he's got more staff than he had, but how on earth do you keep an eye on the activities of a worldwide bank of the size of HSBC? So I'm not sure that you're saying, yes, there's more regulation, so the world will be better. I'm not sure it necessarily will. That's not to say we shouldn't have more regulation, but I'm not sure how effective it will be. And of course, there is also more consumer protection. So conning consumers, which was a sort of regular sport back in the 1960s, at least most of that has stopped, but we've still got PPI. That was conning consumers. Why didn't the fairly tight, strict consumer protection regime that has been in place for the last 20 years or so, why didn't that pick up on PPI much earlier than it did? Right, I think that's enough sort of moaning. It would now be worthwhile just thinking about how English law analyses these things in terms of giving a remedy to people who've been missold something or have been the subject of a dubious transaction. So what civil law rights might you have? And again, I just say note the conflict of laws issues. What law actually governs the transaction? Because obviously in terms of remedies and so on, you need to know that before you can really work out where the parties stand. So we'll proceed on the assumption that we're dealing with pure English law here. And the way that English law would approach these things, I think, is to say, is there actual illegality or unlawfulness which is some form of criminal activity, in which case the criminal law will kick in, or ought to kick in as well. So insider dealing, for instance, is a criminal offence, and the criminal law will kick in if it ever manages to catch the miscreants and successfully to prosecute them. But there's also civil unlawfulness. So some transactions, which may not be criminally unlawful, nonetheless you may not be able to enforce them in civil law. And a classic example of that was gambling. So if you can actually characterize the transaction as a matter of law as a gambling transaction, it used to be, under the 1845 Gaming Act, unlawful. And under the 1890 Gaming Act, it was also unlawful to provide finance for gaming. Now, as we'll see, that's no longer the case, but that was the basic position. And indeed, for a while there was a question mark over the lawfulness of insurance contracts. Were they gambling on the outcome of a future event for a stake, or were they some sort of genuine risk contract? Hence the need in an insurance contract for an insurable interest. And then we get the question, well, is there some duty in tort or contract or equity which you might be able to rely on? Right. I mentioned gaming and I mentioned gambling, the old-fashioned language, gaming and wagering. So under the old law, if I went to Newmarket and I put a stake on a horse and the horse romped home at 50 to 1 and the bookmaker decided he didn't want to pay me, I couldn't sue him for the money I'd won, because that was an unenforceable contract. That's fairly obvious, but you then sort of say, okay, think about insurance. I've mentioned that to you. Think about derivatives transactions, some types of derivatives transaction. Are we really just betting on the outcome of something that might happen in the future? And there was quite a question about derivatives transactions, particularly where the two parties didn't have a genuine underlying interest to protect by the transaction. So they really were just gambling on whether some market price would move one way or the other. And indeed, because of that, legislation was introduced to protect those sorts of transactions from being held to be unenforceable. Well, we then move on to the Gambling Act of 2005, which basically said it's all okay, and they now are, all sorts of forms of gambling are lawful and enforceable. So if you are minded after this to go off to Newmarket tomorrow and enter into a transaction with a bookmaker, at least it's an enforceable transaction for you. A friend of mine took his young son to Newmarket. This boy, I'd known him since he was about the age of 3, and from the time he could read, he subscribed to the weekly Racing Post. And there wasn't a horse in the country that young Edward didn't know about. And so his father took him to Newmarket just for fun, sort of when he was aged about 7 or 8. And, they were standing right up the back of the stand. And Dad says to son, "Well, Edward, which one do you fancy on the first race?" "Oh, Dad, I think so and so." So Dad goes down to the bookmark maker and puts money on. Nobody else has. And this horse romps home. So Dad comes back. "Edward, what do you fancy for the second race?" "Dad, I think such and such." And the people sort of in front sort of just can hear this. And the horse in the second race romps home. Third race, "Edward, what do you think?" By this stage, the people in the 2 or 3 rows in front are sort of turning around to hear Edward. Anyhow, by about sort of the end of the afternoon, he successfully predicted every horse coming home. The whole stand was turning around to hear Edward's opinion on what horses were going to win. Anyhow, poor Edward, he's too young to profit from this adventurous activity, but his father was much richer by the end of the afternoon. And as I mentioned, financial assistance is now okay, and you can go and rape and pillage companies to your heart's content. And then the sort of final point just here is, and this is where sometimes people throw up their hands at English law and say it's too rule-based. And if you are not strictly caught by the rule, it's okay. So we have the problem of technical distinctions, and as long as you can get yourself outside the technicality of what's prescribed, it's fine. And a good example of that, in a slightly different context, is tax avoidance, not allowed. Sorry, is allowed. Tax evasion, not allowed. And where on earth the boundary is between those two is very hard to tell. Is a scheme to avoid paying tax legitimate, so allowable, or illegitimate, so therefore evasion and not allowable? And you might ask yourself sort of the same thing with accounting treatments that I referred to earlier. At what point is your accounting treatment so dubious as not to be a proper method of treating something in a set of accounts? Right, now let's think about some of those things in a little more detail. So the effect of unlawful transactions. Let me give you an example. I go into a shop which sells guns, and I say I'd quite like to buy that rifle, but I haven't got the money, so the shopkeeper gives me credit. He says, "Okay, I'll give you 3 months to pay for it. You can take the rifle now." And I've told him that I want this to go shooting rabbits. Perfectly okay. That's not unlawful. Shooting rabbits is fine. And that's what I've told the shopkeeper. But what if the real reason is to shoot my neighbour? So now my purpose of buying the gun is an unlawful purpose. But how does that affect the shopkeeper who's given me credit for what he thought was a perfectly legitimate purchase? Now, in some situations, the law says if you're innocent of knowledge, then you can enforce your bit of the transaction, provided that bit in itself was not an unlawful activity. But in other situations, it doesn't draw that distinction, and everything is tainted by it. There was a case, for instance, on insurance. Under the old insurance regulation scheme, if an insurance contract was entered into by an unregistered insurer, then that was unlawful. The obvious point is to protect the public against unscrupulous, unregulated insurers. But the Court of Appeal managed to say, at least, thank God, in only an Overton judgment, that illegality tainted all of the insurance contracts written by the unregistered insurer so as to make them illegal and unenforceable by the insured. Now, where's the sense in that? So you can't always tell just what the consequences of unlawfulness will be. Tortious duties, and we'll come back to the question, to what extent does a financial services company, when dealing with a customer, owe that customer a duty of care? What I've done there is just list the basic cases that establish that there can be a duty of care for financial loss arising out of the giving of negligent advice, or indeed even a negligent admission. Contractual duties. To what extent, when a financial services company enters into a contract with a customer, does it undertake some contractual duty towards the customer, for instance, to make sure that the product that's being sold is suitable for the customer? So we might ask the question, to what extent is it a term of the contract for the supplier of the service to exercise reasonable care and skill in making sure that it's a suitable product for that customer? And just final point on those things, that the House of Lords held in the Henderson case that tortious duties and contractual duties can run concurrently in the same transaction. Up until then, it was not sure whether you could have tortious duties when there were contractual duties and vice versa. Tort of deceit, very hard to prove, very rare that you'll get a successful claim in deceit in this country, as opposed to America, where you always finish up any claim with an allegation in fraud. Just standard drafting procedure there, not here. Misrepresentation inducing the entry into a contract. To what extent might we be able to say that the financial services company warranted a certain state of affairs, which misled the customer into entering into the contract? And then we get to fiduciary duties. Now, a concept that's chucked around very liberally, but actually in its application is quite narrow. And fiduciaries basically arise where there's some relationship of trust and confidence, the most obvious bit being where you've got a trustee and a beneficiary. But, and once you can establish the fiduciary duty, then quite onerous responsibilities would follow as a matter of law, but you can, by contract, exclude or limit fiduciary duties. So you might, for instance, say to yourself, well, maybe we could solve this bonus thing by saying that these people, all being senior employees, have a fiduciary duty to do their best by their employer. But of course, by contract, you can vary that, and so you can provide in the contract that bonuses will be paid. So, ignoring fiduciary duties because they're so difficult to establish in most sort of commercial transactions that you're wasting your time, really. We fall back on tort and contract as perhaps the possible ways of imposing liability for missold products and all the rest of it. Well, the problem there is that the judge's basic approach is to say that absent some form of direct admission of responsibility for giving proper advice, when a financial services company transacts a transaction with its customer, they are treated as principal to principal, and therefore duties towards the customer don't exist unless, as I said, you can show they have been specifically assumed. And I've given you a whole series of cases there. And you might want just also to think in that context, to the extent that the duty might arise but is excluded by an exclusion clause. Is there any limit on the effectiveness of an exclusion clause? And you'll see there, if you're interested, the legislation that deals with that. So, now thinking about yourselves as lawyers. In the context of all of that, I ask you some questions about yourselves and how you might go about things as a lawyer. I don't know necessarily what the answers are, and of course the answers will depend on the jurisdiction in which you're practicing. But can you advise a client on a transaction which is criminally unlawful? I think the answer to that is pretty obvious, isn't it? If a customer comes in and says, I want to buy a gun to shoot my wife, well, I'm afraid at that point you've got to say, sorry, no. But what about if it's only civilly unlawful, not criminally unlawful? Can you advise a client and say, well, yeah, I'll draw up the paperwork for you, but it may not be legally effective? Can you do that? Or should you say, as a matter of English law public policy, it frowns on those sorts of transactions. I'm a solicitor of the Supreme Court. I shouldn't be advising you on that. I leave you to think about that one. That's a difficult question. What about if it just involves the breach of a civil duty? So you know that he's going to drive down the highway at 100 miles an hour, which is clearly not only breaking the law, but might well mean that he runs into somebody and injures them. Can you advise him on how he should go about driving down the road at 100 miles an hour when he shouldn't? See it again, your answer to that will depend on various different factors, perhaps. What if it's just of dubious probity, so it's perfectly lawful, but no person with a good conscience would do it? Can you advise on that? Most lawyers, I think, in this jurisdiction would say, I'm not my customer's conscience. It's up to him. I might point out to him that it stinks, but it's up to him to decide whether he wants to go ahead with it or not. He's entitled to my legal representation, and what's more, I'm entitled to the fee I'm going to charge him. As a lawyer, you owe duties to your client. Duties of confidentiality, for instance, not to disclose their affairs. But to what extent might that duty be overridden by other legal duties? And the ones I particularly mention here, things like money laundering. Now, there are very strict rules actually about that, and it has always given me great concern of the extent to which the money laundering rules have eroded my lawyer's duty of confidentiality to my client. If I know that the money that my client has been obtained unlawfully, to what extent, in effect, having been told that in confidence, am I obliged to report it to the police? And the money laundering rules now impose obligations on lawyers to do precisely that. And I, as a lawyer who sort of all my working life worked on the principle that what my client tells me goes no further, I find it very difficult to think, well, it does actually in those situations. Indeed, I can be put in jail for not telling the police. not only where I actually know, but where I ought to have suspected, whether I did suspect or not. Right, we've got just a little bit of time left, so there are just one or two things that I thought I'd mention in relation to recent changes in legislation concerning banks, which I'd like you just to think about and think, to what extent may this have an impact on the things we've been talking about. These arise under the Financial Services Banking Reform Act of 2013. The Act at the moment is being implemented, so we don't actually know the full extent of how far these things are going to go, but it's just worth mentioning the direction of travel for you to think about. The first, I think, very important reform is ring fencing, which basically says that a bank which is providing retail services to its customers should be a bank and nothing else. So it's putting a division between traditional banking activities by a retail bank in favour of its customers from investment banking, essentially. Now, how that ring fencing will be established is not entirely clear. For instance, if you take a big bank like HSBC, are you saying that they have to carve out a retail bank which is a separate legal entity? If so, can it nonetheless be owned by an investment bank? Or are you saying it can all stay as the one entity, but somehow or other we've got to sort of create a proper barrier so that the investment banking activities won't impinge into the retail banking and indeed drag down the retail banking into insolvency? Now, funny thing is that the Americans came up with this as a consequence of the Depression in 1929, and a piece of legislation was passed called the Glass-Steagall Act in the 1930s, which basically said that banks in America had to be banks and couldn't engage in other forms of financial services activities. So they couldn't be insurance companies, they couldn't be investment banks, they were banks. And gradually over the last sort of 30 years or so, that distinction was eroded to the extent that the Glass-Steagall Act was actually repealed, just in time to allow the build-up for about 10 years, up to 2007. Well, yeah, okay, maybe it's a good idea to have some sort of division, but the problem then is, well, insofar as the customer of a bank may genuinely need some other financial product, is the bank to say, well, we're sorry, we can't deal with it, you've got to go elsewhere? If not, or maybe as an alternative to that, we can't actually transact that product with you, but we can arrange it through somebody we know. And are you then on the slippery slope back to where you started? So ring fencing is something. So at least it means that the Russian roulette activities are somewhere else. A new licensing regime for senior executives called the Senior Persons Regime. And not only that, but that regime of identifying senior persons in a financial institution will say, and you are responsible for the activities of your institution in the designated area for which you are registered. and you therefore carry the can personally if something goes wrong in that area. So making senior executives personally responsible for what is going on in the area of the bank that they are meant to be running. And added to that, a further licensing regime for the sort of rank of staff underneath that senior person, saying you can't be one of those unless you are licensed by the regulator. Some rules by which financial institutions should operate, replacing voluntary codes which by and large you haven't worked terribly well. And then for senior persons, a criminal offence of reckless misconduct in the management of the bank. And reversing the onus of proof in proceedings by saying that it's up to the senior person to show that they took all reasonable steps to make sure that what happened didn't happen. Now that's all pretty serious stuff. My guess is that there will be no successful prosecutions under that new criminal offence. It's almost impossible, because basically reckless misconduct is not far off fraud. Very hard to prove, even though the onus of proof is reversed, because those people will just create a paper trail. So just some things for you to think about. Ask yourselves, do you think that will cure all ills? Or, do we need to think further? Do we need to ban bonuses? Should the EU go ahead with the restrictions on bonuses that it's talking about at the moment, which the UK, by the way, opposes? Some thoughts for you. Any questions? Yeah.
Have you personally encountered any of these questions in your?
Yeah.
Did you?
Which one? Big one.
Criminal.
Yeah, I've had clients who've come to me with things and said they want to do this. And you sit back and you think, hang on a minute, there's a criminal offence involved here. So you say no.
It's quite straightforward, but in terms of suspicion, as you mentioned.
Okay, let's take financial assistance. Financial assistance was a criminal offence, and it also had civil consequences. So if financial assistance came to light, then the people involved could be prosecuted for an offence under the Companies Act. And there's a famous case involving a PLC called Guinness. Heard of Guinness? I think it's Guinness, isn't it? Yeah. And essentially what was happening in Guinness in the 1980s was that the share price was going down. And to maintain the share price, the company was lending money to people to go and buy shares. Classic example of financial assistance. And that was all part of the scenario where Guinness was making a bid for another drinks company called Diageo, and the bid was priced in shares in Guinness. So the shareholders of Diageo would be offered in consideration of agreeing to the takeover, in exchange for their shares in Diageo, shares in Guinness. And of course, therefore, to make sure that the shareholders in Diageo thought this was a great idea, it was important to keep the share price of Guinness up, hence the financial assistance scheme. The senior partner of a city law firm was handed the file 2 days before the signing of the transaction by a more junior partner who was going on holidays. The files. He had to deal with it, and he found himself at 2 o'clock in the morning at the signing of the transaction. He failed to spot what was going on in terms of funding the purchase of the shares. Innocent mistake. He was prosecuted for the crime of conspiring to commit financial assistance, being part of a organised scheme, which in the cold light of day he would have no doubt realised. In the end, he successfully defended himself and said there was no way he could have worked it out in the time that was available. But it gives you an example of what can happen to lawyers. That was the end of his career. Completely wrecked it. 2 years criminal proceedings.
But what has happened with the junior partner who was working on the transaction before? So as I understood, the senior partner who was responsible for signing.
The junior partner was stupid and had never realised what was going on.
So he wasn't prosecuted?
No, because he had no criminal intent. Yeah.
Still on financial assistance. In practice, I did come across being able to tie the knots between mixed purposes, where there's some conversations where you have mixed purposes and then financial assistance isn't necessarily the purpose of acquisition is not necessarily the larger purpose of the financial assistance.
Well, if you want to look at those magic words, purpose, as used in what used to be the financial assistance provision, have a look at a case called Brady and Brady in the House of Lords. And if you can work out what the House of Lords was saying, then good luck to you in terms of purpose. Essentially, the House of Lords said purpose means result. If it has the result, then although you may not have perceived that as a matter of purpose, you had the purpose. Brady and Brady, by the way, is a classic example of a bust-up in a family. Very successful road haulage company run by 2 brothers who had a spectacular family bust-up. And the lawyers sort of worked out a scheme to break up the company, but it involved the company giving financial assistance to one of the brothers for the purchase of his bit of the business. And this finished up in the House of Lords as to what was meant by the word purpose. Was the assistance given for the purpose of the acquisition? Yeah.
To what extent do you think bankers and chief execs should be liable for derivatives like contracts for differences that go to the extent that they bring the bank down, like the Anglo-Irish case?
Sorry, that what? Sorry?
Like engaging in derivatives transactions that actually bring the bank down, like Anglo-Irish. Do you think there should be criminal liability for the bankers in that instance?
Well, there would be under this new offence.
Okay. Would you think that's fair?
Yeah.
If they say they didn't.
Yeah, if they get paid so much money, then they deserve to go to jail. I mean, you know, if your argument is that you deserve a bonus for this wonderful job you've done for the bank, So you are reaping a huge financial reward that turns out that it's brought the bank down, then why should you go to jail?
I might be mistaken because I don't know UK labor law, but isn't also one of the big reasons to have big bonuses is because the treatment they get regarding taxes, social security payment related to them are different to basic salary. So
Yeah,
would it be
most
a-
of that's been tightened up. Originally, you paid various types of tax on your salary, but you can structure bonuses as being exempt, but that doesn't apply any longer. But lo and behold, they set up offshore companies. I mean, that's part of the reason why Mr. Diamond was getting 24 million, either dollars or pounds, not much difference these days. Because his basic salary plus bonuses was 12 million, but the tax took it up to 24 million. So the bank, believe it or not, agreed to pay the tax. You'd think, wouldn't you, that if you were earning so much money, you'd be willing to pay your own tax?
You mentioned tax. What about advising tax planning? Could potentially lead to tax evasion.
Yep.
How does it work?
Well, if it's tax evasion, then tax evasion is a criminal offence, and if you've been advising a client to enter into it, then you are guilty of the crime of conspiring to commit a fraud on the revenue, and you can go to jail.
But advising for tax planning is not correct.
Well, if your tax planning is tax avoidance, fine, because that's legitimate. If your tax planning scheme that you advise on and set up is actually held to be tax evasion, evading the payment of tax is a criminal offence.
But isn't there a sort of tricky line?
Very tricky line. Very, very tricky line.
I mean, the client can use this information.
I mean, this actually reflects quite an interesting change in social attitudes in the judges. You get statements of judges all the way up till the end of the 1970s, really, saying things like, you know, a taxpayer is entitled to arrange his affairs in whatever way he likes, and if that means he doesn't pay any tax, good luck to him. And do send us the details of your scheme. So, essentially, judges used to take the view that the revenue was on a hiding to nothing, and if somebody could come up with something which was fancy and meant they didn't pay tax, good luck to him. Well, I think that the social attitude of judges has changed now, especially when you think about how artificial a lot of these schemes are. You know, somebody got caught the other day, maybe some football manager, who claimed that his principal business was as a second-hand car salesman. He didn't own a car. That sort of shows how artificial these things can be. And I think that the judges now are much more inclined to strike down schemes than they would have been 30, 40 years ago. And I think that just reflects a change in general social attitudes. That, you know, we're all in this together. If you don't pay your tax, that means I pay more tax. And you find now sort of anti-avoidance legislation appearing in tax statutes, which sort of does muddy it, because it says, you know, if although it might look legitimate, the real reason is to get out of paying tax, then it's taxable. So some of this legislation is very difficult to ground in sort of rules-based legal systems. I mean, the other thing that you're now obliged to do, by the way, if you're a tax advisor, if you dream up a scheme, you've actually got to notify it to the revenue.
Just in a related line of thought, a parliamentary council once told me that the tax law just didn't need to be as complicated up until the 60s and 70s, because the revenue would just go around the city and basically convince businesses to pay a reasonable amount of tax. And then the attitude changed and people started becoming more aggressive about how much they would pay to start working on the rules. The rules got more and more complicated, and as a result now, the tax legislation is absolutely massive because it has had to develop in such great detail in response to more aggressive tax avoidance. I have a question about, because you raised a question mark over what a lawyer's duties ought to be if the client's proposing to engage in civilly unlawful. And civil wrongs are very broad. You know, a breach of contract is theoretically a civil wrong. And lawyers would advise on situations which may involve a breach of contract quite a lot.
Yeah.
I mean, is it? I mean, how far do you think a lawyer should refuse to advise on something that may be unlawful but not illegal?
Let's take the sort of obvious one first. The breach has already occurred. Perfectly legitimate for a lawyer to advise the client on the consequences of that. That's easy. But then we get into the more sort of difficult. If I intend to breach this contract, please tell me what the consequences are. Probably okay, because you're just advising on the consequences, and then it's up to the client to decide if they will or not. Please assist me in breaching this contract. Please write a letter which disguises the fact of what I'm really up to. More dubious, I think. I mean, different lawyers take different approaches to this. Some lawyers would say, if it's not a criminal offence, you can do it. You know, clients are entitled to advice, and if they want to breach their civil obligations, then they're perfectly entitled to advice from you as to how to do it. I think that's getting a bit dubious myself. I mean, I don't know what you think.
Well, it depends what theory of contract, for example, is subscribed to. Many economists would argue that efficient breach of contract is a great thing, and the less specific performance you allow, the better it is for the economy, because you can pay your damages and get on with your business. But I guess it's more of a moral question, whether contract should be, in some way, should be upheld as sacrosanct, and as a result, more protected.
Different jurisdictions will approach that in different ways too. I mean, the problem for a solicitor is that technically solicitors are officers of the court, and therefore bound to act honourably. If you don't act honourably, you can incur the wrath of the court. Yeah.
Like, how many solicitors and barristers can't practice anymore because of these cases? Is that a significant amount, or is it just like very anecdotal?
Not many.
Yeah. So it's,
it's
very moral, I think.
Most of them have lost their licenses because they've had their hands in the till.
I remember when I was doing my articles of hardship a while ago in Australia, in a quite a small market, so it was a market where all the solicitors knew each other. When the Law Society set came around, and there was a list of people who had been struck off, people would look at it with great interest to see whether there was anyone on there that they knew. It was kind of a gossip generating machine. But I think now, because the legal market's so big, I think it's the dynamics probably changed a little bit.
I just wonder how it works in a huge solicitor's firm when one lawyer is facing this question of moral of moral choice whether to advise or not to advise. So how far this lawyer should raise this question, for example, with his partner or with his senior partner? Because if the case that you have just mentioned about the junior partner who had no idea what was going on behind the transaction, maybe he should have consulted with some risk management partner. So how it works in practice?
How does it work in practice? Well, one problem is that most of these transactions happen with huge speed, and you just usually don't have time to sit back and think, because the demands of the transaction, which may be good or bad, require things to happen very, very quickly. And quite often you just don't have the time to sit back and reflect and think to yourself, well, let me just think about what's going on here. So that's always a problem. But the answer, I mean, the basic answer to your question is if you ever have a doubt, then yes, you should talk to other people about it, because your analysis may be flawed. And with a bit of luck, somebody who's a bit more elderly will have a bit more experience. Not always. I've met some fools who are senior partners of law firms. Yeah.
Yeah, concerning this question, but how if a junior lawyer just worked on a part of the contract which is not really related to the unlawful part, will he still do that?
No, because if his task is limited to a specific area, and that in itself is justifiable and discrete, then he or she should be okay with that. But if what he's doing or she's doing raises questions or should raise questions, then it's not sufficient to say, I'm just doing this discrete thing, because you are now aware of the wider context. And if it looks, if you can't work out how it fits into the wider context, then yes, you should have questions.
What about revealing this? I just wondering how it works in terms of who does the government investigate, who is advising this client? Or
Yeah, I mean, well, in the Guinness example, for instance, it all came to light. And of course, then the prosecutors started digging around to see what had happened, who'd been involved, how, who had been instrumental in seeing the transaction into existence, which is a matter of record.
if it was a private conversation somewhere in the reception?
Well, the problem is that somebody says, well, when they're prosecuted by the police, well, I relied on what Mr. So-and-so said. Well, tell us what Mr. So-and-so said. And you go and ask Mr. So-and-so, what did you say? Any more? Yeah.
So I understood lawyers and bankers that have to disclose it to the government and to the tax authorities when their clients are money laundering and committing fraud. What about the reputational damage of bankers and lawyers who come in touch with these clients? It's obviously a strong argument for them not to do it because the more clients you rat out to the government, the more your reputation could be damaged.
So reputational damage.
Clients will not come to you for more grey stuff.
or maybe more will. I mean, if you get a reputation as a hotshot tax lawyer who does wonderful schemes which save people a lot of tax, you'd be amazed how many will be queuing up at the door to get that wonderful tax advice. I mean, in money laundering, obviously, banks and so on, which are being caught money laundering, obviously, it's not a great idea.
question. So, and the question I have is, deals with this. We've been talking about the debate between over-regulation of the capital market and the market generally, and the comparison between the UK and the US, and why the US probably has a more booming market than the UK. And then I look at this latest, Financial Services Banking Reform Act and similar regulation. I wonder, is the UK still favoring the over-regulation of the market, looking at the difference between it now and the US, or shouldn't it be going towards a more liberal market environment?
Well, the US has clamped down, hasn't it? You've got the Volcker Act and all that sort of thing. But I think the general trend up until 2007, 2008 was sort of liberalising regulation in markets and so on. This idea that the market is a perfect instrument to transact business and to almost to regulate itself. And that's obviously been shot to bits. So both in the US and here and at the EU level, we're seeing increasing amounts of regulation. The question I put to you is, will that actually result in any change in behaviour or bad practice? I'm not sure it will. You'll catch a few people, but other people will manage to find ways around it. Right.
Well, thanks very much. Thanks, Andrew. Thanks for giving us so much time to come and speak to us today. I think everyone will agree it's been fascinating to get your views on all these topics. So let's show our appreciation.